So very good evening all the participants. We have already shared the PPT for this session. Let me share it once again. I have already shared in the group.
Good evening, sir.
Good evening, ji. Good evening. Desktop. Yes. So this is the PPT for today's session, which I have already shared in the group. I hope my screen is visible. So first of all, let us understand the ecosystem of this IBC. So as we know, side by side, two things operate. One is the parliamentary system, then executive and judiciary. Regarding the executive, IBBI has been made the regulator for this insolvency profession. And this IBBI is regulating whom? They are regulating insolvency professional agencies, information utilities, and IPs. And IPs are simultaneously being regulated by insolvency professional agencies also. So there is a dual monitoring of the activities of the IPs. Please switch off your mics because there might be echo due to that. So these insolvency professionals, they are being monitored by the insolvency professional agencies as well as IBBI. It is something similar to a student taking admission in a college. So he is being regulated by the college as well as the university. Similarly, here he is being regulated by the insolvency professional agencies where he takes the enrollment, and he is being regulated by the IBBI, which is the ultimate regulator. Parallel to this is the judiciary. In the adjudication process, there are different adjudicating authorities for corporate and non-corporates. For corporates, the adjudicating authority is NCLT, National Company Law Tribunal, and the appellate authority is NCLAT. For non-corporates, who may be individuals or partnership firms or other non-corporate entities, DRT is the adjudicating authority and DRAT is the appellate authority. And ultimately, the appeal lies to Supreme Court. And as we know, the Constitution guarantees us certain fundamental rights. And in case there is any violation of fundamental rights, so writ petition can be filed in High Court or in Supreme Court. In High Court, by virtue of Article 226, and in Supreme Court by virtue of Article 32. So most of the petitions which have been filed in the High Courts or Supreme Courts are exercising the right under those writ petitions. So the petition is drafted like this, that, my lord, there is a violation of our fundamental right. IBC as it stands today, there are 5 parts. First is preliminary, second is it deals with corporate persons, and there are various processes in part 2. First is normal CIRP, then fast track CIRP, liquidation, voluntary liquidation, and pre-pack process. Chapter 3 deals with insolvency resolution and bankruptcy for individuals and partnership firms. Part 4 deals with regulations of insolvency professionals, agencies, and information utilities by IBBA. And part 5 is miscellaneous, which deals with the government powers, board procedures, and other acts which have impacted the insolvency law. And then there are schedules, 12 schedules, which contain the amendments to other acts, which were effected due to this IBC. Regarding this adjudicating authority, so National Company Law Tribunal is the adjudicating authority for corporate debtors, and debt recovery tribunals is for individuals and partnership firms. There are application to adjudicating authority rules which describe the procedure and formats for various applications, and filing is also fees. And it is important to adhere strictly to the formats and procedures to avoid dismissal on technical grounds. And as we know, if you want to initiate an application, then under section 7, financial creditors can move the application by filling up form 1. Under section 9, operational creditors can file the petition. And forms 3, 4 and 5 are relevant for that. Form 3 for demand notice, form 4 for payment against invoice, and form 5 for filing petition. And section 10 through form 6, the corporate applicant can file the application when there is a default by the corporate debtor. And in all these cases, consent of the IRP is obtained in form 2. Another important aspect here is the definition of relatives. So the definition of relatives is relative. So it depends upon the act which we are studying. The definition of relative is different in Companies Act, it is different in Income Tax Act, and then IBC. Section 56(2)(10) of Income Tax Act says that what is the definition of relative. So it says a relative means spouse of the individual, brother or sister of the individual, brother or sister of the spouse of the individual, brother or sister of either of the parents of the individual, any lineal ascendant or descendant of the individual, any lineal ascendant or descendant of the spouse of the individual, or spouse of the persons referred to in clauses 2 to 6. So this is the definition of relative as per section 56(2)(10) of the Income Tax Act. Then the definition of relative under the Companies Act is different. So section 277, section 277 refers to the term relative, and it says relative with reference to any person means anyone who is related to another if they are members of HUF, they are husband and wife, or one person is related to the another in such manner as may be prescribed, which then takes us to rules. And for this, rule 4 is important. Rule 4 of the company's specification of definition rules, which defines the terms of relatives. So list of relatives in terms of clause 77 of section 2. And it says a person shall be deemed to be the relative of another if he or she is related to another in the following manner. Father, provided that the term father includes stepfather. Mother, provided that the term mother includes the stepmother. Son, provided that the term son includes the stepson. Son's wife. Daughter, daughter's husband. Brother, provided that the term brother includes the stepbrother. Sister, provided that the term sister includes the stepsister. So this is the definition as per the Companies Act. Now definition of relative as per IBC. Section 524 capital A. First of all, we have to see the definition of related party in relation to an individual. So related party in relation to an individual means a person who is a relative of the individual or a relative of the spouse of the individual. Partner of LLP or LLP or partnership firm in which the individual is a partner. A person who is a trustee of a trust in which the beneficiary of the trust includes the individual, or the terms of the trust confer a power on the trustee which may be exercised for the benefit of the individual. So if there is a trust and you are a trustee in that trust, and beneficiaries of the trust include the individual, or the terms of the trust confer a power on the trustee which may be exercised for the benefit of the individual. Suppose the beneficiaries of the trust include the individual or the terms of the trust confer a power on the trustee which may be exercised for the benefit of the individual. Suppose you are entitled to certain benefits under the trust. So that trust and you are related parties. Private company in which the individual is a director and holds along with his relatives more than 2% of its share capital. Public company in which the individual is a director and holds along with relatives more than 2% of its paid up share capital. Body corporate whose board of directors, managing director or manager in the ordinary course of business acts on the advice, directions or instructions of the individual. Then LLP or partnership firm whose partners or employees in the ordinary course of business act on the advice, directions or instructions of the individual. Person on whose advice, directions or instructions the individual is accustomed to act. Company where the individual or the individual along with his related party owns more than 50% of the share capital of the company or controls the appointment of the board of directors of the company. So this definition is also important. And relative with reference to any person means anyone who is related to another in the following manner. Members of HUF, husband, wife, father, mother, son, daughter, son's daughter and son, daughter's daughter and son, granddaughter's daughter and son, granddaughter's daughter and son, brother, sister, brother's son and daughter, sister's son and daughter, father's father and mother, mother's father and mother, father's brother and sister, mother's brother and sister. And wherever the relation is that of a son, daughter, sister or brother, their spouses shall also be included. So this is the definition of a relative as per the various acts. I have shared a chart also in the group, chart of relatives. Now let us have a look at the various processes which are involved in this insolvency law. First is the corporate insolvency resolution process, where the corporate which is under insolvency, which is under financial stress, looks for resolution of its insolvency. So that is why it is called corporate insolvency resolution process. And as you know, corporate here includes company, LLP or any other body corporate incorporated under any law. So CIRP. In CIRP, we look for a resolution of the economic crisis which we are facing. And the CIRP application can be put by financial creditors, operational creditors, or the corporate debtor itself. So all these three persons, they can file the application, and these are the form numbers. Now, suppose you file the application, then what could be the various steps involved? The various steps involved could be, naturally, the first step will be the adjudicating authority will look at the application form, and if it is complete in all respects, they will admit it, otherwise they may reject it. And they may give some time of 7 days for rectification of any defects in the application. And then the process will move on. First of all, public announcement will be made, claims will be invited, claims will be collated, committee of creditors shall be constituted, and then the committee will do various meetings. So they will invite expression of interest. They will issue invitation for expression of interest. They will call the resolution applicants. They will evaluate their competence to run the company. The resolution applicants may be subjected to certain ineligibilities which are given in section 29A. They will put forth the various resolution plans by way of which they want to resurrect the company. And then ultimately one out of them will be selected as the successful resolution applicant, and then there will be implementation of the insolvency resolution process. And then the company will come out of that trouble. But the company will remain as a going concern. Management will change. So this is the process of CIRP. Similar is the process of fast track, whereby the time limit is just half. Like in case of CIRP, the normal period is 180 days. Here the period is 90 days. There the extension can be of 90 days maximum. Here the extension could be of 45 days maximum. But fast track process is limited to only certain types of corporate persons. Say small companies, startups, or companies having asset size not exceeding 1 crore. Now, Third is the process of PPIRP. So PPIRP is again a process of insolvency resolution by corporate MSMEs only. So here only MSMEs are eligible. And one of the main features of this PPIRP is that the management stays in control. The corporate debtor stays in control unless COC decides to divest him of the control in case he is playing a fraud on the company. And here, in case of PPIRP, the financial creditors or operational creditors are not allowed to file the application. Like in case of CIRP or fast track, financial creditors or operational creditors can also file the application. But in case of PPIRP, only the corporate debtor is allowed to file the application. And here they are allowed to put forth a base resolution plan also. So they are given the priority to give the base resolution plan. And if either of these things are not successful, suppose CIRP, no resolution applicant came or no resolution plan was approved, so then ultimately liquidation may follow. And in case of liquidation also, there will be again public announcement, there will be again filing of claims. In case some claims are not filed, then the claims which were filed during CIRP, they may be taken. And then there are certain timelines also. And in liquidation also, every attempt is made to first of all sell it as a going concern. First of all, the possibility of compromise or arrangement is explored for the first 90 days. And then also an attempt is made either to sell it as a going concern or to sell the business of the corporate as a going concern. And if that is not successful, then even the assets may be sold in parts. Now, voluntary liquidation is slightly different. In case of voluntary liquidation, there is no default as such. So, even a financially solvent company can go in for voluntary liquidation. There could be various reasons. Suppose the company was formed for a particular period or for execution of a particular project and that project is over. So now they want to liquidate the company. But it is possible only when there are sufficient assets in the company which are through which they are able to pay the creditors of the company. So it could be either a debt-free company or it is able to pay its debts in full. Only then voluntary liquidation process is possible. Another important feature of this voluntary liquidation is that the role of the adjudicating authority is minimum in case of voluntary liquidation. And most of the processes, most of the approvals, most of the reports are submitted to the corporate person only. In case of individuals and partnership firms, which is covered in part 3, there are 3 processes. It starts with fresh start, whereby the individual who has got very limited means, very limited assets, liabilities, and debts, so he can go, or an income, he can go in for fresh start process, whereby he is not required to pay anything and he is absolved of all his liabilities except certain debts. Excluded debts are certain debts through which he is not discharged despite a discharge order being issued against that individual. Another process in case of part 3 is individual insolvency. In case of individual insolvency, all the provisions related to individuals and partnership firms have not yet been identified. Out of individuals and partnership firms or non-corporate persons, a particular class is carved out. Those personal guarantors who have given a guarantee to a corporate person. So only provisions relating to insolvency and bankruptcy of personal guarantors to corporate debtors have been notified. So there are rules and there are regulations for personal guarantors to corporate debtors. And in case of fresh start individual insolvency, the default amount is 1000 rupees only, as against the default amount in case of corporate persons, which is 1 crore. In case of pre-pack process, the default amount is 10 lakhs. Now, the insolvency professional, he can assume various roles. First of all, he may be appointed as an interim resolution professional. He may be elevated as resolution professional. He may act as authorized representative. He may act as liquidator. He may act as voluntary liquidator. He may act as bankruptcy trustee, administrator, and now there is a concept of facilitator also. So these are the various roles which an insolvency professional can assume. Now, if we see the various processes, so there are various forms for accepting assignments under various processes. Like in case of CIRP and fast track, first of all, form 2 has to be signed, then form AA in case he is appointed as an RP. In liquidation, form AA is there. In case of prepack, form P1 is there and form P3 is there regarding terms of appointment. In case of voluntary liquidation, the appointment is done by the corporate person. So it is through a resolution. In case of personal guarantors to CD, form A is there, and in case of personal guarantors to CD bankruptcy process, form A is there. So these are the various forms which an insolvency professional has to sign while accepting his assignment. And I have shared here the various forms also. Like form 2 is there. If we read form 2, it says it is to be submitted under Rule 9 of the Insolvency and Bankruptcy Application to Adjudicating Authority rules. Written communication by proposed IRP. Suppose a financial creditor wants to file an application with the adjudicating authority against the corporate debtor, which has committed a default of 1 crore or more. So what he will do? He will approach an insolvency professional and he will get this form 2 signed even before filing the application. So this form 2 is a written communication by proposed IRP. It is addressed to NCLT and they say from name and address of the registered office of the proposed IRP in the matter of this name of the CD. Subject is written communication in connection with the application to initiate corporate insolvency resolution process in respect of this. So he says, I, an insolvency professional registered with IPA having registration number, have been proposed as the IRP by name of the applicant financial creditor in connection with the proposed corporate insolvency resolution process. In accordance with Rule 9, the Insolvency and Bankruptcy Application to Adjudicating Authority rules, I hereby agree to accept appointment as the IRP if an order admitting the present application is passed. So they say that if this application is admitted, then I agree to accept the appointment. He state that the registration number allotted to me by the board is this and that I am currently qualified to practice as an insolvency professional and disclose that I am currently having the following assignments in it. So he will cite the various assignments which is having as either IRP or RP or liquidator or voluntary liquidator, as authorized representative, as resolution professional, bankruptcy trustee, and other. And I certify that there are no disciplinary proceedings pending against me with the board or name of the IPA of which he is a member. And affirm that I am eligible to be appointed as a resolution professional in respect of the corporate data in accordance with the provisions of this IBC insolvency resolution process for corporate persons regulations. And make the following disclosures in accordance with the Code of Conduct for Insolvency Professionals as set out in the Insolvency and Bankruptcy Board of India Insolvency Professional Regulations. So he is saying that I am eligible to be appointed and I shall make this following disclosures. Okay? Then optional certification if required by the applicant making an application under these rules. I hereby certify that the facts averred by the applicant in the present application are true, accurate and complete and a default has occurred in respect of the relevant corporate data. I have reached this conclusion based on the following facts and opinions. Signature of the insolvency professional. So this is the format of the form which is required to sign. Then form AA. Form AA is the written consent to act as RP. Because once the application has been admitted, so we have seen that as soon as the financial creditor or the corporate debtor wants to move an application with the adjudicating authority, he will get this Form 2 signed from the insolvency professional. And the insolvency professional herein will state that what are the assignments he is already having and that he is entitled to accept this assignment and is not suffering from any of the disqualifications, and he shall be making the disclosure in accordance with the code of conduct. Form AA. Form AA is the written consent to act as RP, and it says it is given to the committee of creditors. Name of the corporate debtor, written consent to act as RP. So it says, I, an insolvency professional enrolled with the IPA and registered with the board, note that the committee proposes to appoint me as resolution professional. In accordance with Regulation 31A of this CIRP regulations, I hereby give consent to the proposed appointment. So this consent form is taken from the resolution professional by the COC. And it says that I declare and affirm as under, I am registered with the board and not subjected to any disciplinary proceedings. I do not suffer from any disability to act. I am eligible to be appointed. I shall make the following disclosures in accordance with the code of conduct, and I am having the following processes in hand. So these are the processes, various processes which he may be holding. In case he is acting as authorized representative, then Form AB is required to be filed. And this form we will give to the IRP. Form AA in case of liquidation process regulation. So the meaning is that in case of different processes, different forms are there. Now, because as an insolvency professional, he is regulated by the insolvency professional agencies. So understanding the insolvency professional regulations is very important. And in the various forms also which he has signed, we have seen that there is a reference to code of conduct. So first of all, let us see the provisions regarding insolvency professionals. So what it says? It says registration of insolvency professionals. So no individual shall be eligible to be registered as an insolvency professional if he is a minor, if he is not a person resident in India, if he doesn't have the qualification and experience specified in Regulation 5 or Regulation 9 as the case may be, has been convicted by any competent court for an offence punishable with imprisonment for a term exceeding 6 months, or for an offence involving moral turpitude, and a period of 5 years has not elapsed from the date of expiry of the sentence, provided that if a person has been convicted of any offence and sentenced in respect thereof to imprisonment for a period of 7 years or more, he shall not be eligible to be registered. So he can never register himself. He is an undischarged insolvent or has applied to be an insolvent. He has been declared to be of unsound mind, or he is not a fit and proper person. So in all these cases, he will not be eligible to be registered as an insolvency professional. And for the purpose of determining whether an individual is a fit and proper person under these regulations, the board may take account of any, just a minute, consideration as it deems fit, including but not limited to the following. First is integrity, reputation and character, absence of convictions and restraint orders, and competence including financial solvency and net worth. So these are the criteria for registration as an insolvency professional. And no insolvency professional entity recognized by the board under Regulation 13 shall be eligible to be registered as an insolvency professional if the entity and or any of its partner or director, as the case may be, is not a fit and proper person under Clause G of Subregulation 1. So you can practice as an insolvency professional as an individual or as an entity also. Now, what are the qualifications and experience? it says subject to the other provisions of these regulations, an individual shall be eligible for registration if he has passed the limited insolvency examination within 12 months before the date of his application for enrollment with the insolvency professional agency, or and has completed a pre-registration educational course within 12 months from the date of payment of non-refundable application fees under regulation 6, as may be required by the board from insolvency professional agency after his enrollment as a professional member, and has successfully completed the national insolvency program as may be approved by the board, successfully completed the postgraduate insolvency program as may be approved by the board, experience of 10 years in the field of law after receiving a bachelor's degree in law, 10 years in management after receiving a master's degree in management or 2 years full-time PG diploma in management, or 15 years in management after receiving a bachelor's degree from a university established or recognized by law or an institute approved by All India Council of Technical Education, or 10 years of experience as chartered accountant, registered as member of ICI, company secretary, registered as member of ICSI, cost accountant, registered as member of Institute of Cost Accountants of India, or an advocate enrolled with the Bar Council. So these are the qualifications. And for the purpose of this regulation, only professional and managerial experience shall be considered. Explanation 2. For the purpose of computing the total experience of 10 or 15 years under subclause 3, there shall be included experience of any period under subclause 4. The total experience of 10 years under subclause 4, there shall be included experience of any period under any of the items of that subclause. That means, suppose a person has been a chartered accountant for a period of 6 years and company secretary for 4 years, then also he will be eligible. That is the meaning. Where an individual has experience of 9 years under subclause 3 and experience of 6 years under subclause 4, he shall be considered having experience of 15 years. Okay. Where an individual has experience of 6 years under item A and experience of 4 years on item D, he shall be considered as having total experience of 10 years. Now, application for certificate of registration. An individual enrolled with an insolvency professional agency as a professional member may make an application to the board through the insolvency professional agency of which he is a member in Part 2 of Form A of the second schedule to these regulations, along with non-refundable application fees of 20,000 rupees to the board. These days there is a combined application form. An insolvency professional entity eligible for registration as an insolvency professional shall make an application to the board in Form AA, along with the non-refundable application of fees of 2 lakh rupees. And board shall acknowledge the application within 7 days of its receipt. The insolvency professional agency shall verify and forward the application to the board within 30 days from the date of payment of fees, as the case may be, excluding the time given by the insolvency professional agency to the professional member for submitting additional documents, information, or clarification. The board may require the applicant to submit within reasonable time additional documents, information, or clarification that it deems fit, and board may require the applicant to appear within reasonable time before the board in person or through its authorized representative for clarifications required for processing the application. And if the board is satisfied, then it will grant the certificate of registration in Form B within 30 days of the receipt of the application. And the registration shall be subject to the condition that the insolvency professional shall at all times abide by the code, regulations, guidelines issued by the IPA of which he is enrolled, and at all times continue to satisfy the requirements under Regulation 4, undergo a continuous professional education as may be required, not outsource any of its duties and responsibilities under the code except those specifically permitted by the board, pay to the board a fees of 20,000 rupees in case the insolvency professional is an individual, or a fees of 2 lakh rupees in case he is an insolvency professional entity every 5 years after the year in which the certificate is granted, and such fees shall be paid on or before 30th April. and then 12% interest in case it is not paid in time. In addition to this fees, he has to pay to the board a fees calculated at the rate of 1% of the professional fees earned for the services rendered by it as an insolvency professional in the preceding financial year on or before the 30th April of every year, along with the statement in Form E. Provided further that where the IP is an insolvency professional entity, it shall pay to the board a fees calculated at the rate of 1% of the professional fees earned for the services rendered as an insolvency professional in the preceding financial year on or before 30th day of April every year, along with the statement in Form G. Besides that, he has to pay to the board a fee specified under sub-regulation 2 of Regulation 31A within a period of 30 days after the end of each quarter or upon closure of the processes, whichever is earlier, along with a statement in Form EA. And quarter means the period of 3 months commencing on the first day of January, April, July, or October. He will not render the services as an insolvency professional unless he becomes a partner or director of an insolvency professional entity recognized by the board if he is not a citizen of India. So, if a person is not a citizen of India and he wants to practice as an insolvency professional, then he has to become a partner or director of an insolvency professional entity. He cannot practice as in his individual capacity. He has to take prior permission of the board for shifting professional membership from one IPA to another, and after receiving no objection from both the concerned insolvency professional agencies. He has to take adequate steps for redressal of grievances. He has to maintain record of all assignments undertaken by it under the code for at least 3 years from the completion of such assignment. He shall abide by the code of conduct specified in the first schedule, and in case of an insolvency professional entity is an insolvency professional, it shall allow only a partner or director, as the case may be, who is an insolvency professional and holds a valid authorization for assignment to sign and act on behalf of it. Abide by such other conditions as may be imposed by the board. Authorization for assignment. An insolvency professional, so this is something similar to certificate of practice. An insolvency professional shall not accept or undertake an assignment after 31st December 2019 unless it holds a valid authorization for assignment on the date of such acceptance or commencement of such assignment as the case may be. A refusal to grant certificate. If after considering an application made under Regulation 6, the board is of the prima facie opinion that registration ought not to be granted, it shall communicate the reasons for forming such an opinion and give the applicant an opportunity to explain why its application should be accepted within 15 days of the receipt of the communication from the board to enable it to form an opinion. And communication under sub-regulation 1 shall be made to the applicant within 30 days of receipt of the application, excluding the time given by the board for presenting additional documents, information or clarifications, or appearing in person as the case may be. And then he has to revert within 15 days. And after considering the explanation, if any, given by the applicant, the board shall communicate its decision to accept the application along with the certificate of registration or reject the application by an order giving reasons thereof within 30 days of the receipt of the explanation. Now, there is a provision for issue and surrender of authorization for assignment. What it says? It says an insolvency professional agency shall inform the board when it issues or renews an authorization for assignment, suspends or cancels an authorization for assignment, revokes the suspension of an AFA, accepts the surrender of an AFA, accepts the application for surrender of membership and strikes the name of the professional member from its register, expels the professional member, or receives intimation of demise of an individual or winding up or dissolution of a company, LLP or registered partnership firm, and strikes the name of the professional member from its register within 1 working day of taking such action. And board shall take note of the information received under sub-regulation 1. Now, let us directly go to this code of conduct, which is very important. And there is a reference to the code of conduct whenever the IP is accepting any assignment. So he always says that I will make the disclosures in accordance with the code of conduct. So code of conduct for insolvency professional. It says first is integrity and objectivity. An insolvency professional must maintain integrity by being honest, straightforward, and forthright in all professional relationships. An insolvency professional must not misrepresent any facts or situations and should refrain from being involved in any action that would bring disrepute to the profession. An insolvency professional must act with objectivity in its professional dealings by ensuring that its decisions are made without the presence of any bias, conflict of interest, coercion, or undue influence of any party, whether directly connected to the insolvency proceedings or not. An insolvency professional must disclose the details of any conflict of interest to the stakeholders wherever he comes across such conflict of interest during an assignment. An insolvency professional appointed as an IRP, RP, liquidator, or bankruptcy trustee should not itself acquire directly or indirectly any of the assets of the debtor, nor knowingly permit any relative to do so. Okay? So this was regarding integrity and objectivity. Second line is independence and impartiality. So what it says an insolvency professional must maintain complete independence in its professional relationships and should conduct the insolvency resolution, liquidation, or bankruptcy process, as the case may be, independent of external influences. And in cases where the insolvency professional is dealing with assets of a debtor during liquidation or bankruptcy process, he must ensure that he or his relatives do not knowingly acquire any such assets, whether directly or indirectly, unless it is shown that there was no impairment of objectivity, independence, or impartiality in the liquidation or bankruptcy process and the approval of the board has been obtained in the matter. An insolvency professional shall not take up an assignment under the code if he, any of his relatives, we have seen the definition of a relative, any of the partners or directors of the IPE of which he is a partner or director, or the insolvency professional entity of which he is a partner or director is not independent in terms of the regulations related to the processes under the code in relation to the corporate person, debtor, and its related parties. An insolvency professional shall disclose the existence of any pecuniary or personal relationship with any of the stakeholders entitled to distribution under section 53 or 178 of the code. And just and the concerned corporate person debtor as soon as he becomes aware of it, by making a declaration of the same to the applicant, committee of creditors, and the person proposing appointment as applicable. An insolvency professional shall disclose as to whether he was an employee of or has been in the panel of any financial creditor of the corporate debtor to the committee of creditors and to the IPA of which he is a professional member, and the agency shall publish such disclosure on its website. So there are certain situations where he may be eligible to be appointed, but he has to disclose certain things. An insolvency professional shall disclose its relationship, if any, with the corporate debtor, other professionals engaged by it, financial creditors, interim finance providers, and prospective resolution applicants to the IPA of which he is a member within the time specified hereunder. So suppose he is related with the corporate debtor, then he has to disclose this relationship within 3 days of his appointment. If he is related to the registered valuer, accountant, legal professional or other professionals appointed by him within 3 days of the appointment of the professional. Relationship of the IP with the financial creditors within 3 days of the constitution of COC. Just a minute. Right. Now it's okay. थोड़ा सा कई बार ओवरलैपिंग हो जाता है, अब हो जाएगा ठीक. If he has a relationship with the interim finance providers, so within 3 days of the agreement with the interim finance provider. Just a minute. If he has a relationship with prospective resolution applicants, then within 3 days of the supply of information memorandum to the prospective resolution applicant. And if he relationship with any of the above comes to the notice or arises subsequently, then within 3 days of such notice or arising. An insolvency professional shall ensure disclosure of the relationship, if any, of the other professionals engaged by it with itself, the corporate debtor, the financial creditor, the interim finance provider, if any, and the prospective resolution applicant to the IPA of which he is a member within the time specified below. So if he is the relationship of the other professional with the insolvency professional, then within 3 days of the appointment of the other professional. Relationship of the other professional with corporate debtor within 3 days of the appointment of the other professional. Financial creditor within 3 days of the constitution of COC. Relationship of the other professional with interim finance providers within 3 days of the agreement with the interim finance provider or 3 days of the appointment of the other professional, whichever is later. Relationship with prospective resolution applicant within 3 days of the supply of information memorandum to the prospective resolution applicant or 3 days of the appointment of the other professional, whichever is later. And if he comes to know it subsequently, then within 3 days of such notice or arising. And for the purpose of clause 8b and c, above, relationship shall mean any one or more of the following 4 kinds of relationship at any time or during the 3 years preceding the appointment of other professionals. So what is the kind of relationship? Where the insolvency professional or the other professional, as the case may be, has derived 5% or more of his or its gross revenue in a year from professional services to the related party. So then he is considered to be related. What is the criteria? 5% or more of his or its gross revenue in a year from professional services to the related party. Second, where the insolvency professional or the other professional, as the case may be, is a shareholder, director, KMP, or partner of the related party. So, in case is a shareholder, director, KMP, or a partner of the related party, then he is deemed to be in relationship and he has to disclose it within 3 days. Where a relative, spouse, parents, parents of spouse, sibling of self and spouse and children of the insolvency professional or the other professional, as the case may be, has a relationship of kind A or B with the related party. Insolvency professional is not deriving 5% or more, but his brother, his spouse is deriving 5% or more. Then also is deemed to be related and he has to disclose this relationship within 3 days. ठीक है? Where the insolvency professional or the other professional, as the case may be, is a partner or director of a company, firm or LLP, such as an insolvency professional entity or registered valuer, the relationship of kind A, B, or C of every partner or director of such company, firm, or LLP with the related party. So actually, this insolvency professional and the other professional, they should not have any conflict of interest. An insolvency professional shall ensure timely and correct disclosures by it and other professionals appointed by it, and shall provide a confirmation to the IPA of which he is a professional member, to the effect that the appointment, if any, of every other professional has been made at arm's length relationship. An insolvency professional shall not influence the decision or the work of the COC or debtor or other stakeholders under the code so as to make any undue or unlawful gains for itself or its related parties, or cause any undue preference for any other persons for undue or unlawful gains, and shall not adopt any illegal or improper means to achieve any malified objectives. Then professional competence. An insolvency professional must maintain and upgrade his professional knowledge and skills to render complete professional service. Representation of correct facts and correct misapprehensions. An insolvency professional must inform such persons under the code as may be required of a misapprehension or wrongful consideration of a fact of which he becomes aware as soon as may be practicable. An insolvency professional must not conceal any material information or knowingly make a misleading statement to the board, the adjudicating authority, or any stakeholder as applicable. Then timeliness. An insolvency professional must adhere to the time limits prescribed in the code and the rules, regulations, and guidelines thereunder for insolvency resolution, liquidation, or bankruptcy process, as the case may be, and must carefully plan all its actions and promptly communicate with all stakeholders involved for the timely discharge of its duties. An insolvency professional must not act with malified or be negligent while performing its functions and duties under the code. Then information management. An insolvency professional must make efforts to ensure that all communication to the stakeholders, whether in the form of notices, reports, updates, directions, or clarifications, is made well in advance and in a manner which is simple, clear, and easily understood by the recipients. An insolvency professional shall prominently state in all its communications to a stakeholder its name, address, email, registration number, and validity of AFA, if any, issued by the IPA of which he is a member. An insolvency professional must ensure that he maintains written contemporaneous records for any decisions taken, the reasons for taking the decision, and the information and evidence in support of such decision. This shall be maintained so as to sufficiently enable a reasonable person to take a view on the appropriateness of its decisions and actions. An insolvency professional must not make any private communication with any of the stakeholders unless required by the code, rules, regulations, and guidelines thereunder, or orders of the adjudicating authority. An insolvency professional must appear, cooperate, and be available for inspections and investigations carried out by the board. any person authorized by the board or the IPA with which he is enrolled. Just a minute. An insolvency professional must provide all information and records as may be required by the board or the insolvency professional agency with which he is enrolled. An insolvency professional must be available and provide information for any periodic study, research, and audit conducted by the board. Confidentiality. An insolvency professional must ensure that the confidentiality of the information relating to the insolvency resolution process, liquidation, or bankruptcy process, as the case may be, is maintained at all times. However, this shall not provide it from disclosing any information with the consent of the related parties or required by law. Then occupation, employability and restrictions. An insolvency professional must refrain from accepting too many assignments if he is unlikely to be able to devote adequate time to each of his assignments. And there is a clarification, an insolvency professional may at any point of time not have more than 10 assignments as RP in CIRP, of which not more than 3 shall have admitted claims exceeding 1000 crore rupees each. An insolvency professional may resign from the assignment subject to the recommendation of the COC in a CIRP process, consultation committee in liquidation process, the debtor or the creditor in the insolvency resolution process of personal guarantors to the corporate debtor, as the case may be, and the approval of the adjudicating authority. ठीक है? An insolvency professional must not engage in any employment when he holds a valid authorization for assignment or when he is undertaking an assignment. So he has to be full time in practice. He cannot be in job when he is undertaking any assignment. Where an insolvency professional has conducted a CIRP, he and his relatives shall not accept any employment other than an employment secured through open competitive recruitment with or render professional services other than services under the code to a creditor having more than 10% voting power, the successful resolution applicant, the corporate debtor, or any of their related parties until a period of 1 year has lapsed from the date of his cessation from such process, so as to avoid conflict of interest. An insolvency professional shall not engage or appoint any of his relatives or related parties for or in connection with any work relating to any of his assignments. And for the purpose of this clause, the insolvency professional, which is an insolvency professional entity, may engage or appoint its partners or directors, as the case may be, for or in connection with any work relating to any of its assignment other than work related to valuation and audit of the debtor. An insolvency professional shall not provide any service for or in connection with the assignment which is being undertaken by any of his relatives or related parties. For the purpose of clause 23A to C, related party shall have the same meaning as assigned to it in clause 24A of section 5, but does not include an IPE of which IP is a partner or director. For the purpose of this clause, the insolvency professional, which is an insolvency professional entity, may provide any service other than service related to valuation and audit for or in connection with the assignment which is being undertaken by any of its partners or directors, as the case may be. An insolvency professional must not conduct business which in the opinion of the board is inconsistent with the reputation of the profession. Then remuneration and costs. An insolvency professional must provide services for remuneration which is charged in a transparent manner, is a reasonable reflection of the work necessarily and properly undertaken, and is not inconsistent with the applicable regulations, because they have given the minimum fees but they have not given the maximum fees. But they say that it should be a reasonable reflection of the work necessarily and properly undertaken, and it should not be inconsistent with the applicable regulations. An insolvency professional shall disclose the fees payable to it, the fees payable to the IPE, and the fees payable to the professionals engaged by it to the IPA, of which he is a professional member, and the agency shall publish such disclosures on its website. An insolvency professional shall raise bills or invoices in its name towards its fees, and such fees shall be paid to it through banking channel. An insolvency professional shall ensure that the insolvency professional entity or the professional engaged by it raises bills or invoices in their own name towards their fees, and such fees shall be paid to them through banking channel. An insolvency professional shall not accept any fees or charges other than those which are disclosed to and approved by the persons fixing its remuneration. An insolvency professional shall not accept, share any fees or charges from any professional and or support service provider who are appointed under the processes. An insolvency professional shall disclose all costs towards the insolvency resolution process cost, liquidation cost, or costs of the bankruptcy process as applicable to all relevant stakeholders, and must endeavor to ensure that such costs are not unreasonable. An insolvency professional shall, while undertaking assignment or conducting processes, exercises reasonable care and diligence and take all necessary steps to ensure that the corporate person complies with the applicable laws. An insolvency professional shall not include any amount towards any loss, including penalty, if any, in the insolvency resolution process cost or liquidation cost incurred on account of non-compliance of any provisions of the laws applicable on the corporate person while conducting the insolvency resolution process, fast track insolvency resolution process, liquidation process or voluntary liquidation process under the code. ठीक है. Then gifts and hospitality. An insolvency professional or his relative must not accept gifts or hospitality which undermines or affects his independence as an insolvency professional. An insolvency professional shall not offer gifts or hospitality or a financial or any other advantage to a public servant or any other person intending to obtain or retain work for himself or to obtain or retain an advantage in the conduct of profession for himself. Then second schedule is there, Form A. As you can see, Form AA, application for registration. So we have seen that an insolvency professional has to conduct himself in a professional manner, and there are certain qualifications which are attached to that particular assignment, and if there is any conflict of interest, then he has to disclose that conflict of interest. So a case study will be asked on this code of conduct alone. They will be asking 3 questions and 6 marks are given for this case study. So what we will do is we will share a case study in the group and you will try to solve that case study. The definition of relative we have seen, and then we can on our own form certain types of instances where he should or should not accept the assignment. So the question could be posed like this. Suppose Mr. A is an insolvency professional. He is otherwise qualified to accept the appointment, but his maternal uncle is a shareholder in the company. So the question is whether this relationship should be disclosed, whether he should accept the assignment or not. So these are the type of questions which may be asked in the examination. You have been appointed as an insolvency professional. Your wife is working as an advocate and she is getting 10% or more of her turnover from the client of which you have been appointed as an insolvency professional. So in such situation, what you will do, whether you will resign, you will continue to hold that assignment, or whether you will make a disclosure. So all these things, this type of questions may be asked in the examination. So you can go through all these forms, you can go through the code of conduct, and we will be giving you a case study for solving. Pooja Vasudevaji, your inputs on this?
Regarding, sir?
Regarding this code of conduct, matlab, in what way we
Uh,
can make it easily understandable for students? I think we can post some questions in the group that so that they are able to exercise their mind on it, whether there could be two, three situations. Number one is, in certain situations, he may not accept the assignment. We'll go through those regulations also. And besides that, there could be certain situations where there is no bar to accepting the assignment, but he has to make disclosure.
disclosures, yes.
Sir, one question.
Yes, please.
Sir, with regard to like an insolvency professional, can he employ a professional in under him and for assistance? Is there any bar on such employment?
He can employ, he is entitled to employ any number of professionals. They will be basically, since it is a going concern, and during CIRP, it is a going concern. So, whatever actions he is taking those actions on behalf of the corporate debtor. The powers of the board stand suspended, and he is acting as all in all of that company. So basically, he is the chief compliance officer of that company. He is responsible for all the compliances. He can appoint any number of professionals. He can terminate employees. He can amend the contracts. He can cancel the contracts. He can enter into new contracts. He can enter into arbitrations. So he can do all things which a company can do but on behalf
There
of
is,
the company
uh,
only. So there
there
could
is
be two
one suggestion.
situations. Number one, first situation could be that he is, say, taking assistance of his own staff. So as far as taking assistance of his own staff is concerned, that is covered under his fees only. Like suppose as a chartered accountant, I am doing audit. My staff is also assisting me, but I am not charging for my staff. This is first situation. Second situation is, in addition to the role he is required to perform, because roles and responsibilities of an insolvency professional are outlined in the code itself, that what are his roles and responsibilities, and normally he is not allowed to delegate his roles and responsibilities. But there could be some other functions, like suppose HR function is there, some accountancy related work is to be done. So for that, he can appoint professionals. He can appoint accountants. He can appoint professionals to manage, to run it as a going concern. Because there could be a situation where there is no staff in the company, or all the staff have already left the company. So he is very well authorized to appoint. But what he has to see, that there is no conflict of interest. He is not appointing his relative. So he cannot appoint his brother as an accountant. That is the issue, because that will be hit by the code of conduct.
Got it, sir. Got it.
Yes, Pooja Vasudevaji, you were saying something?
Sir, I just wanted to say that he can employ any professionals provided such services are not available within the company.
Right. Because if everything has to be justified, it should not incur any extra expenditure on the company. Suppose some accountant is already available in the company, so he can make use of that accountant. But if he feels that he is not competent or is not cooperating, then he can appoint somebody else also. So because everything, but regarding the costs, whatever costs he is incurring, that is subject to ratification by the committee of creditors. So unless the committee of creditors ratifies the cost incurred by the insolvency professional, so there is not much point.
Sir, I have one query.
Yes.
Uh, can in the code of conduct there was one point in which the penalty cannot be included in the CIRP cost.
Right. Because actually,
If
during
so, sir,
CIRP or during fast track, insolvency professional is held accountable for all the compliances. Suppose ITR return has to be filed, or TDS return has to be filed, or GST return has to be filed. And if the fault can be attributed to the negligence of the insolvency professional, then he will personally bear that loss. That is the meaning. So he cannot book it to insolvency resolution process cost. He has to bear it on his own. That means out of his own pocket.
sir, does it include additional fees paid
No, additional fees is
with
different.
ROC?
Penalty is different. If it is in the nature of a penalty, because in case of
Right.
additional fees, normally no hearing is required. But penalty is normally leviable only once an opportunity of being heard is given. So if an opportunity of being heard is given, despite that he is held guilty and penalty is levied, then and penalty is attributable to the default on the part of the IRP or RP, then he has to personally bear that loss and he cannot book it to insolvency resolution process cost. That is the meaning.
Sir.
Yes, Jayji.
Sir, we
Yes.
were considering this definition of relative as per the Income Tax Act, Companies Act, and as per IBC.
Right.
Yeah.
Yes.
Sir, you mentioned about step son, stepdaughter in case of, I think, company and IBC. But in case of Income Tax Act, there is only the definition consists of only son or daughter. In income tax, does a stepson also is considered a relative, or is not so, not considered?
Actually, if we go by strict interpretation, so then whatever is written in the law, we have to go by. We have to go by it.
By that, so in income tax, the classification with regard to relatives would be different from
Yes.
the one.
Right, because Income Tax Act is also in our syllabus, Companies Act is also in our syllabus, and IBC is also in our syllabus. So they could pose to you a general question that the definition of relative in Income Tax Act, Companies Act, and IBC are different or same. So that way they may ask you questions. That is the idea. So we should at least know that the definition is different in different acts.
And sir, you mentioned about this authorization for assignment. You said it
Right,
is it is akin to certificate of practice that
right,
we get as chartered accountant or
right,
this
right,
company said.
right.
Now, this authorization for assignment, so long as they do not revoke that authorization for assignment, and so long as you do not exceed the number of
Right.
assignment,
Mhm.
it holds good. And so long as you make the payment of the fees, I think the payment
Right,
of
right. But it has to be renewed every year.
Acha, it has to be renewed every year. So
Yes.
they like is it that in the authorization for assignment they mention the date from the date on which it is
Yes, yes, yes,
effective?
yes, yes,
Yeah, and sir,
yes.
one more clarity if you can give.
Mm.
You
Mhm.
were mentioning about the 3 days, sir, like 3 days, 7 days. These are the number of days that comes in IBC.
Yes.
Now, you mentioned about 3 days. How for example, if I have to consider 3 days, should I consider the first day, second day, and third day, or the number of days starts from the next day to the third, or that is the fourth day? How do they consider this number of days?
Actually, regarding the number of days, there is first of all we have to go as per the General Clauses Act. So, as per the General Clauses Act, if we see, so they say normally we exclude the day, we exclude the first day, and then we consider 3 days.
Acha, okay. So the first day is excluded, and you start from the next day.
Yes, and limitation acts also for 1 day is excluded.
Okay. Yeah, thank you, sir.
And we have to also keep this fact in mind that here the days run concurrently. There are no holidays. So once time has begun to run, 3 days means 3 days, even if there are Sundays in between. So Sunday will not get you an additional day. So what we will do is, we'll keep it simple today. I've tried to explain to you some of the expectations from an insolvency professional, that he has to be independent, he has to be objective, he has to be impartial, he has to disclose his interest. And just one more thing we can discuss today. Just a minute. And that will be the eligibility for appointment of an insolvency professional. And then it will complete the entire thing. So the eligibility for appointment, once we see, it is almost same in all the processes. So let us see the eligibility for appointment in CIRP process. So eligibility for appointment is given in regulation number 3 of the CIRP regulations. So what it says? Eligibility for resolution professional. So it says an insolvency professional shall be eligible to be appointed as an IRP or RP, as the case may be, for a corporate insolvency resolution process of a corporate debtor, if he and all partners and directors of the IPE, of which is a partner or director, are independent of the corporate debtor. So independence has to be there. And what is the meaning of independence? Then they have explained. It says a person shall be considered independent of the corporate debtor if he is eligible to be appointed as an independent director on the board of the corporate debtor under section 149 of the Companies Act 2013, where the corporate debtor is a company. So suppose you are an individual, you are otherwise qualified. So if the company were to appoint you as an independent director, whether they can appoint you? If they can appoint you as an independent director, then you will be considered independent of the corporate debtor. This is first condition. And where independence is shown, so independent qualifications to be appointed as independent director, they are given under section 149 of the Companies Act, where the corporate debtor is a company. We'll see those provisions also. Second is, you are not a related party of the corporate debtor. A related party of the corporate debtor, related in relation to an individual, because you are an individual. So related party in relation to an individual is described in section 524A. Section 524A also we have seen. So if you are not a related party of the corporate debtor, you are not holding more than 2% of the share capital, you are not having more than 50% of the share capital, and so many other things we have seen. So then also you are considered independent. You are not an employee or proprietor or partner of a firm of auditors or secretary auditors in practice or cost auditors of the corporate debtor, or of a legal or consulting firm that has or had any transaction with the corporate debtor amounting to 5% or more of the gross turnover of such firm. Suppose you are running a consultancy firm. Your turnover is say 100 crores. And if you are getting 5 crores or more from this CD, then you cannot be appointed as IRP or RP of the CD, from which you are getting 5% or more of your turnover, whether you are an employee or partner or proprietor of that firm. If you are an auditor, secretary auditors or cost auditor, then also you cannot be employed. If you are a related party of the corporate data covered under section 524A, you cannot be appointed. Okay? Then you should be eligible to be appointed as an independent director as per the criteria which is given in section 149. Okay? At this condition of this firm of auditors, secretarial auditors, or cost auditors, or of a legal, it has to be seen in the last 3 financial years. Suppose you were a auditor of the company 10 years ago, and now you have become an insolvency professional, so you can be appointed. So there is no bar. So this condition has to be seen in the last 3 financial years only. Where the committee decides to appoint the IRP as RP or replace the IRP or replace the RP under section 27, it shall obtain the written consent of the proposed resolution in Form AA. Form AA also we have seen. An IRP or RP, as the case may be, shall make disclosures at the time of his appointment. Those disclosures also we have seen, and thereafter in accordance with the code of conduct. So code of conduct also we have studied. An IRP or RP who is a director or partner of the IPE shall not continue as IRP or RP, as the case may be, in a CIRP if the IPE or any other partner or director of such insolvency professional entity represents any other stakeholder in that corporate insolvency resolution process. So because 2 persons, say one partner is sitting on one side of the table, the other partner is sitting on the other side of the table, that is not permitted. Okay? So for this we have to see the definition of stakeholder also. So stakeholder definition is there, and what it says, so stakeholder basically means the persons who are having a stake in the company. Who are entitled for distribution as per section 53. Now let us see the qualifications for appointment as an independent director in section 149 of the Companies Act, because that is also important aspect. So for that you can go to my website. So this is my website. So you go to Knowledge Bank and you go to Acts and you go to Corporate Laws, Companies Act. In Companies Act, now you have to see the definition 149. 149 will be there in Management and Administration. या इसमें होगा अपॉइंटमेंट एंड क्वालिफिकेशन ऑफ डायरेक्टर्स, है ना, चैप्टर 11 इसमें होगा 49 149 ये है कंपनी टू हैव बोर्ड ऑफ डायरेक्टर्स. ठीक है. ये 149 subsection 6, it talks of independent director, and what it says, an independent director in relation to a company means a director other than a managing director or a whole-time director or nominee director. ठीक है. Who in the opinion of the board is a person of integrity and possesses relevant expertise and experience, who is or was not a promoter of the company or its holding subsidiary or associate company, who is not related to the promoters or directors in the company, its holding subsidiary or associate company, who has or had no pecuniary relationship other than remuneration as such director, or having transaction not exceeding 10% of his total income or such amount as may be prescribed with the company its holding, subsidiary or associate company, or their promoters or directors during the two immediately preceding financial years or during the current financial year. ठीक है. None of whose relatives is holding any security of or interest in the company, its holding subsidiary during the two immediately preceding or during the current financial year, provided that the relative may hold security or interest not exceeding 50 lakh rupees or 2% of the paid up capital. So these are the qualifications or disqualifications for being appointed as independent director. ठीक है. Is indebted to the company, its holding company, or in excess of such amount as may be prescribed. So if you go to prescribed, so prescribed में आपको ये तो कुछ और ही ले आया यहाँ. Has given a guarantee or provided any security for such amount as may be prescribed. अच्छा, ये यहाँ कुछ गलत रह जा रहा है, मैं इसको देख लूंगा. ये वुमेन डायरेक्टर पे ले जा रहा है एक्चुअली. कोई बात, I'll get it corrected. Has any other peculiarity. तो बेसिकली ये 149(6) में दे रखा है क्राइटेरिया कि भाई कौन कौन इंडिपेंडेंट डायरेक्टर अपॉइंट हो सकता है. अगर यहां पर आप इंडिपेंडेंट डायरेक्टर अपॉइंट हो सकते हो तो वहां पर भी हो सकते हो आप इंसॉल्वेंसी प्रोफेशनल. दिस इज द मीनिंग. तो सबसे पहले तो ये है कि इफ यू वांट टू बी अपॉइंटेड एज एन आईआरपी और आरपी, तो आपको क्या देखना है कि भाई वेदर आई एम एलिजिबल. रेगुलेशन 3 में देर आर एलिजिबिलिटी रिक्वायरमेंट्स. उसके बाद में क्या है कि आई एम बीइंग गवर्न्ड बाय ए कोड ऑफ कंडक्ट ऑल्सो. तो मुझे डिस्क्लोजर भी देना है विद इन ए पीरियड ऑफ 3 days इफ देर इज एनी कॉन्फ्लिक्ट ऑफ इंटरेस्ट. तो ये सब चीजें आई हैव टू बी वेरी कॉशियस while taking up an assignment. So on this you can go through all these provisions on your own, and we will post one or two case studies, and besides that we will try to post some 10-15 relationships also. है ना. आप भी कुछ रिलेशनशिप पोस्ट कर सकते हैं बेस्ड ऑन द कोड ऑफ कंडक्ट या फिर जो रिलेटेड पार्टी के रेगुलेशंस हमने पढ़े हैं इस बारे में कि भाई what are the conditions in which you cannot accept the assignment, and what are the situations in which you can accept the appointment but you have to make a disclosure. ठीक है.
Sir,
Yes.
the form AA,
हाँ
IRP has to submit it to the COC.
हाँ
Then,
बिल्कुल.
तो सर उसका टाइम लिमिट्स कब है, कब तक सबमिट करना होता है उसने? सीओसी की कॉन्स्टिट्यूशन के बाद सबमिट
हाँ
करेगा?
ऐसा है ना. इन दी फर्स्ट कमेटी मीटिंग भाई सीओसी क्या करती है, सीओसी क्या करती है अपनी फर्स्ट कमेटी मीटिंग में डिसाइड कर लेती है कि आईआरपी को आरपी बनाना है या इसको रिप्लेस करना है.
राइट.
उसके बाद में भी कभी भी रिप्लेस कर सकते हैं विद 66% मेजोरिटी.
यस
देखिए
सर.
ऐसा
तो
होता है ना
फॉर्म AA से वो
इनिशियली.
पहली मीटिंग
हाँ
में.
इनिशियली जो है, इनिशियली तो वो फॉर्म 2 साइन कर देगा आईआरपी. है ना. वो
हाँ जी.
तो
जी.
जैसे फाइनेंशियल क्रेडिटर ने एप्लीकेशन लगानी है तो फॉर्म 2 के साथ में लगेगी एप्लीकेशन एडजुडिकेटिंग अथॉरिटी को. एप्लीकेशन लग गई.
यस सर.
सबसे पहले तो ऐसा भी हो सकता है कि
राइट सर.
एडजुडिकेटिंग अथॉरिटी ही उसको रिप्लेस कर दे. ऐसा भी हो सकता है कि जब उसके अगेंस्ट मान लो कोई डिसिप्लिनरी प्रोसीडिंग स्टार्ट हो गई. ठीक है. जब उसने फॉर्म 2 साइन किया था तब कोई
यस सर.
डिसिप्लिनरी प्रोसीडिंग नहीं थी, लेकिन जब तक एप्लीकेशन
जी.
एडजुडिकेटिंग अथॉरिटी के पास पहुंची तब तक वो उसके अगेंस्ट में डिसिप्लिनरी प्रोसीडिंग स्टार्ट हो गई. तो फिर उसको अपॉइंट नहीं करेगी एडजुडिकेटिंग अथॉरिटी. उस केस में क्या करेंगे, बोर्ड से मांगेंगे, किसी दूसरे को अपॉइंट कर देंगे. बट सपोज इज नॉट सफरिंग फ्रॉम एनी ऑफ द डिस्क्वालिफिकेशंस, तो उसको अपॉइंट कर देंगे. फिर सीओसी वो क्या करेगा, पब्लिक अनाउंसमेंट करेगा, क्लेम्स इनवाइट करेगा, सीओसी कॉन्स्टिट्यूट करेगा. सीओसी पहली मीटिंग में अपनी डिसाइड करेगी कि भाई उसको रखना है या किसी दूसरे को अपॉइंट करना है. अगर दूसरे को अपॉइंट करना होगा या उसको भी रखना है तो भी दोनों चीज में उसको फॉर्म AA साइन करना है. अब क्या
यस सर.
क्या क्वेश्चन था आपका.
से यही पूछना था कि फॉर्म डबल ए किस स्टेज पे उसने देना होता है, सीओसी की फर्स्ट मीटिंग में देगा मीन्स वो, इफ ही
हाँ
इज बीन कंफर्म्ड एज आरपी।
हाँ बिल्कुल बिल्कुल, हाँ जब कंफर्म हो जाएगा तब, बिल्कुल। और उसके अलावा भी अगर मान लो कोई रिप्लेस करेंगे उसको, तो रिप्लेस में फिर वो फॉर्म 2 साइन नहीं करेगा। मान लीजिए उसको हटा दिया, कोई नया आ गया, वो भी फॉर्म डबल ए ही साइन करेगा। मान लीजिए रामलाल को हटा के श्यामलाल को ले आए सीओसी, तो जो श्यामलाल है वो फॉर्म 2
राइट,
साइन नहीं करेगा, फिर वो फॉर्म डबल ए ही साइन करेगा सीधा। हाँ।
राइट सर।
Sir, just one question, sir.
यस यस प्लीज।
With regard to these PPTs that you are sharing for every session, sir, can we get these PPTs at one place and on your website, or if we can have an access of all these
Actually,
PPTs?
I will post all these PPTs in the group, so you can download it and you can make your own folder. The reason is that at times these PPTs also undergo a change, है ना?
Uh-huh.
So when we keep on revising these also based on the interaction. So we will be posting in the group, and we can post all the PPTs also in the group at one go. So you can make your own folder. You can download it in your own folder on your own laptop. It is for you. Whether you want to take print out or you want to read it online, it's up to you.
And sir, with regard to these video lectures, you mentioned that you will have access to these video lectures, about
Right, right,
150.
right. Regarding those video lectures, actually, what I will do is, first of all, I will share with you the video lectures of the earlier batch, because the syllabus also has undergone a change. So I'll be sharing with you the videos of July batch, which is based on the latest syllabus. So July batch videos, which are more than 30, so I will be sharing that playlist with you. So you can download all those videos and you can watch them at your own pace. Suppose you are at an advanced stage of study, so you can do your own study also. So those video lectures also I will be sharing. Besides that, there are video lectures on allied laws. So lot of video lectures are there on each of the acts which are covered in allied laws, like Companies Act, Partnership Act, LLP, Surface. So lot of videos are there. So I'll be sharing those video lectures also.
Okay, sir. Thank you.
Right. Okay. And if you want any particular video or any particular PPT, you can write in the group. All of you are added in the group. You can write to me separately also in case you want to ask anything. You can call me also. You can send me an audio note also, depending upon your convenience, and I'll reply accordingly. At whatever stage, suppose you feel stuck somewhere, you are not able to understand a particular aspect, you just pick up the phone, give me an audio note, send me an audio note, I'll reply.
Sir, I had heard the first session, I think, where you started, because I had not joined at that time. I just joined day before yesterday. So I think I missed the first two session, where one session, I think you actually discussed about how do we prepare for the IBC exams, or for the IBC code actually.
Okay.
And I think you had also covered section 1 to 3. I think that particular this thing video recording, this thing you have sent. Now the thing is that, sir, with regard to the, I actually appeared for this exam, but there was only 1 month that I could prepare.
Okay.
So I had actually I had actually bought books from the ICI with regard to the handbook. They have the publications with regard to certain handbook and frequently asked questions on IBC, and they've also covered various allied laws. And they have also this question banks, are actually question bank.
Right.
But I think what I could not exactly cover is with regard to the case studies. We could not. I mean, there are no publications on case studies.
Okay.
That
So
there's a
we have developed a lot of case studies. There are more than 50 case studies. So we will be sharing all those case studies with you.
Yeah. Okay, sir. Okay.
Yes.
Because I think these 30 in my exam, the one that I appeared, there were around 65 questions, and 30 as
Right. 30
30
questions
as
are
you
of 1 mark and 35
and
questions are of 2 marks. So 35
2
questions,
marks.
they are based on case studies only.
Case studies, yeah.
Yes.
And the thing is that, because of the case studies, at times you are not able to exactly grasp, the particular questions that they have taken from the case study, and to what particular part of the law they are asking these questions. So quite confusing with to this. So how do you actually grasp the case studies and related questions to the
Right.
particular
So we'll be discussing at length. You will be there. You will be there with us till you pass the exam. Don't worry. So we'll be deliberating in detail on all these things.
yeah, okay, so thank you.
And if you want a repeat of section 1 to 3, that also can be done. No issues.
No, I mean, I'll go through because actually, sir, I did go through the first session where you have discussed, the preliminary part on how to prepare for the IBC
Right.
and how to read the IBC code, and I'll go through the section 1, 2, 3.
Right.
Uh, so
Okay.
yeah, thank you,
Okay.
sir.
Okay. Okay. Jayesh ji, any questions from your side?
हेलो।
हेलो, हाँ जी जयेश जी।
यस यस सर। आज मेरा फर्स्ट लेक्चर ही है, तो अभी तो
हाँ
जो आया समझ में आ गया है।
हाँ
आगे
हाँ।
के जैसे अभी कुछ आप जो आपसे आगे वाले बात कर रहे हैं, वो बोले आगे 2 सेशन हो गए हैं क्या? कि बेस्ट स्टार्ट फ्रॉम टुडे 16 से होने वाला था, वो आज ही स्टार्ट हुआ है ना? मैं
आज ही
कह रहा कि
स्टार्ट हुआ,
आगे
हाँ
दो
हाँ,
सेशन
आज
चले
ही
जाए।
स्टार्ट हुआ। हाँ जी हाँ जी हाँ जी। 16 को हुआ नहीं क्योंकि वो इनकम टैक्स की लास्ट डेट एक्सटेंड हो गई ना, उस वजह से नहीं हो पाया।
राइट राइट राइट। ओके, तो टुडे इज फर्स्ट सेशन ना?
टुडे इज फर्स्ट सेशन, यस यस यस।
ओके
हाँ जी।
ओके
अब आप
ओके।
बताइए, सेक्शन 1 to 3 आप दोबारा कवर करना चाहते हैं क्या? यू विल कवर विद दोज और ऑडियो लेक्चर्स, कैसे करोगे आप? मैं वीडियो लेक्चर भेजे जो आपको।
मैंने अभी तक देखे नहीं, सच्ची बताओ तो सर, एक बार देख लेता हूँ, फिर अगर कुछ
ओके ओके।
रहेगा तो मैं आपको पोस्ट कर दूंगा।
ओके, आप मुझे ग्रुप में शेयर लिख दीजिएगा, कोई बात नहीं। बट नेक्स्ट
राइट।
क्लास इज ऑन सैटरडे ओनली। अब जो नेक्स्ट क्लास
ओके,
होगी वो
सैटरडे।
सैटरडे को
ओके
होगी। सो वी कैन डिस्कस इन द ग्रुप
ओके
के फ्रॉम वेयर वी कैन स्टार्ट, है ना?
ओके। एंड टाइमिंग इज सेम?
टाइमिंग इज 8 to 9:30 PM।
ओके सर।
ओके जी, गुड नाइट।
थैंक यू गुड।